of all, for coming. This is amazing. This conference is certainly a marathon, and you guys are at mile 23. You made it this far. You're almost done. So thank you. I appreciate it. I was guessing we were going to have 3 people here, so it's nice to see this many faces up this early. I have one caveat to begin with. If you are an ESA guru and you read the program and you said, oh my gosh, they're applying Section 4D to endangered species, and that's why you're here this morning, I am so sorry, because we were talking about the application of Section 4D to threatened species, and there was a typo in the program. So if you're here to learn about endangered species, you can go back to bed and come back to the conference at 10:50. My name is Tanya Sandra, and I'm with the Center for Biological Diversity. I put this panel together. With me is Kristen Monsell from the Humane Society of the United States, and Brendan Cummings, who's also from the Center for Biological Diversity. Our plan this morning is I'm going to talk to you guys about the statutory language, some regulations, and sort of walk through historically the application of Section 4D to threatened species. And then Kristen's going to talk about sport hunting in 4D, and Brendan's going to talk about climate change in 4D. My only other caveat is, and I think this probably applies for all 3 of us, this panel is really focused on Fish and Wildlife Service. The agency formerly known as NIFS, NOAA Fisheries, also has a lot of 4D rules, and I wanted to try to bring that in, but I think that just deserves its entire own panel. So there's a lot of litigation going on right now, particularly in the Northwest, about fish hatcheries, and I think maybe there's a couple people here who are doing that work. So if you have questions about that in particular, if those folks are here, we can direct you to them, but we're really sort of focused on Fish and Wildlife Service and not what NOAA Fisheries is up to, which is also a very interesting story. Except for climate. Yes. Yes, that's right. Okay. Anyways, I'm going to go ahead and get started. And this is sort of a little roadmap for us on where we're going and what we're going to do. So we have to start, obviously, we're talking about the Endangered Species Act, and for those of you who are not familiar with the statute and who didn't freak out about its application to endangered species, let me give you just a little bit of quick background. So how the Endangered Species Act works is most of its protections kick in when a species gets listed, and a species can be listed as an endangered species, and if it's listed as endangered, all of the Section 9 prohibitions apply to that species automatically under the statute. If a species gets listed as threatened, and this is really what our panel is going to talk about, the prohibitions apply unless a 4D rule says otherwise. And so the bulk of this panel is going to be sort of focusing on that last thing that I just said and how we get there. So I'm going to walk you through that. So we start off with Section 9 of the Endangered Species Act. And typically we think about this as being the prohibition on take, and that's certainly one aspect of Section 9, but if you look at actually all the prohibitions, and it's these lettered paragraphs, it prohibits the sale of listed species, it prohibits import, export, all sorts of good things. So when we're talking about protections for threatened species that get extended by the application of Section 9, it's much more than just the prohibition on take. What take prohibits, and that's usually what we focus on domestically, is anything from harm, harassment, injury, death, attempts to engage in that kind of conduct. But Section 9 is much broader. And I think what's really critically important, because we tend to gloss over this a lot, is if you look at Section 9 and that first paragraph, paragraph 1, it only applies to endangered species. It doesn't apply to threatened species. So how do we get to our threatened friends? Well, we do that by going back in the statute to Section 4D. And so this is the statutory language of Section 4D of the Endangered Species Act. And I've divided it up into sort of three sections. The first one is the first sentence, and it has sort of 2 key parts to it. It says that the service shall issue regulations that are necessary and advisable for the conservation of the species. The second part of Section 4D says that the service may extend any of those prohibitions in Section 9 to a threatened species. And then the last part of the statutory section of 4D really is talking about cooperative agreements between states and Fish and Wildlife Service as species get listed in their states. We're really not going to focus on that. The application of that, it's just a whole sort of different subject from what we're going to be talking about. So I'm going to sort of walk you through the first two parts of Section 4D. So the first one is necessary and advisable for the conservation of the species. And conservation is defined within the statute and has a pretty broad definition. And the two things that I focus on with conservation is the use of all methods and procedures which are necessary to bring the species essentially to the point where it's recovered. And this is, for those of you who are familiar with Section 7 of the Endangered Species Act, litigation in that area, this is really where the definition of conservation is where we get the recovery standard. And that's important. But the rest of the definition of conservation tends to get sort of glossed over, and it's really critically important that you look at the very, very end of this definition, because it makes it abundantly clear that the regulated taking, so the actual going out and shooting, killing, trapping, whatever, a species that is protected under the Endangered Species Act, it can only occur in extraordinary case where population pressures are such that they actually need to go in and eliminate some of the members of the species. And so that's going to be important. We're going to talk about that more later. But I just wanted to highlight those are sort of two key aspects of this definition of conservation. And because the Secretary, because the service shall issue regulations for the conservation of the species, this is sort of the criteria by which you sort of look at those rules and the lens through which you apply them. Then the other important part, and then we'll get into this more, is the necessary and advisable language. And I just put up a couple cases for you guys that have interpreted that language, and it's been interpreted so far to really give the service great discretion. So necessary and advisable, sort of, that's up to them to determine that. But in my view, and the arguments that we've made, is that that is curtailed, though, by this definition of conservation. So they can decide what's necessary and advisable within the context of this really great statutory definition of conservation. So how has this played out? We have this great statutory language. What has Fish and Wildlife Service done with it? Well, they started off issuing a bunch of 4D rules at the beginning of our current sort of existing Endangered Species Act, and most of those 4D rules were for fish, frankly, and said you can take these fish species in compliance with state law. And around the same time, they were sort of trying to figure out what are we going to do with all these threatened species, because they were listing a lot of species as the Act had become incorporated and passed and was being funded. And so what Fish and Wildlife Service did is they adopted this blanket regulation, and this is the one that's at 50 CFR 1731A. And it's the first paragraph up there. And essentially what this blanket regulation does is it applies all the prohibitions in Section 9 to threatened species. And so Fish and Wildlife Service said that's where we start. We get to decide, the Secretary may apply Section 9 prohibitions to threatened species, and Fish and Wildlife Service said, done, we've done that. Now there's two different parts in here that have sort of exceptions to that. Subpart A of this part, those are all the other exceptions for species. And so for an example, captive bred wildlife, there's exceptions from take prohibitions for those guys. So what the subpart A is referring to are some of those exceptions that exist, so captive bred wildlife, Alaskan Native, so on and so forth. And then 1721C, which you can sort of see from this list, it's a particular aspect of the take prohibition, again applying to state cooperative agreements. So in essence, what this says is the take prohibitions apply to all threatened species, and that's generally how most people think about them. And then I just included for you the language of 50 CFR 1721, which is the regulatory language which mimics Section 9 prohibitions. So, this is sort of one of these regulatory morass things. It would have been nice if they just said in 1731A, these are the things that are prohibited. Instead, they said, refer back to 1721. So this is what 1721 says. So it's essentially all the stuff that's in Section 9. So that's where we started off with Fish and Wildlife Service. They have a number of 40 rules for fish. They said you can take fish in compliance with state law. And I think that the agency must have realized, oh my gosh, we don't want to keep on passing all these 4D rules and making all these decisions. So they applied this blanket regulation that extends Section 9 prohibitions to threatened species. And this is what the service was saying about their decision to do that in the late 70s. And I'm happy to share this PowerPoint with any of you, especially if you're working on 4D rules, but this is really important because this is really what the agency was thinking at the time that they took this regulatory action. And I think it's really important, it's really helpful language for us as we're looking at 4D rules today. We also have some case law, and we'll get into this again a little bit more, but one of my favorite cases on the early sort of interpretation of this blanket regulation extending on the prohibitions of threatened species came from the DC Circuit. And obviously this is the Sweet Home decision that goes up and interprets the regulatory definition of harm, but it had some really great language before it went up that doesn't get overruled by the Supreme Court decision. That's also incredibly helpful for working on 4D rules. So, this is sort of the argument, this is how it works. So you have these three parts to section 4D, right? We walk through those. So the first part requires special rules for the conservation of the species. The second part says that the Fish and Wildlife Service may extend the prohibitions in Section 9 to threatened species. The Fish and Wildlife Service did that. They extended all the prohibitions in Section 9 to threatened species. So now, the service has to show that what they call a special rule, a 4D rule, is necessary and advisable for the conservation of the species. And most of the time what they're doing is they're passing a special rule, 4D rule, to say certain activities are not prohibited. You can engage in them. They're exempt from the Section 9 prohibitions. And in order to do that, they have to say it's necessary and advisable for the conservation of the species. We'll talk later about whether or not all the courts agree with that interpretation, whether the agencies agree with that, but that is a pretty clear-cut way to read both the statutory language and what the service has done. So how does this work? And I think it's really interesting. We sort of started out with this, these fish species, and we have at least, somewhere on the order of 42, probably more 4D rules from the Fish and Wildlife Service. And there were a couple early exceptions, and Kristen's going to talk a little bit about the gray wolf. There's a grizzly bear 4D rule, but by and large, they were all just these fish 4D rules for a long time. And then in the early 90s, Fish and Wildlife Service sort of started playing around with this a little bit. And so if you go back and you look at the Coastal California Gnatcatcher, that was one of the first 4D rules that sort of had this different twist to it. It's very different language from all the previous ones, except for grizzly bears and gray wolves. And essentially what it did is it allowed, taken in accordance with this particular state law, and it said as long as you're complying with that state law, then the Section 9 take prohibitions don't apply to you. And then later on what the service did with Canada lynx is they allowed trade in pelts of captive bred lynx. And again, generally speaking, sale, import, export, those things are prohibited under Section 9. This 4D rule allowed that. And then the really big one, and where we really started to see sort of this shift in how Fish and Wildlife Service was using this provision of the law, was in 2001 with Prebble's meadow jumping mouse. And that it goes on for a really, really, really long time. I don't want to get into it in too much detail, but you're dealing with a small critter that goes all over the place, and people really, really, really were concerned with this listing because you were talking about, well, if we're trying to control rodents, if we're trying to engage in agricultural activities, if we want to landscape our backyard, if we want to use water, a whole host of things were implicated by the listing of that species. And so that was really the first time that Fish and Wildlife Service came up with this mega 4D rule that exempted a whole host of activities. So what are we seeing now? And what we've seen in the past couple of years, and I'm going to touch on, this morning I'm going to touch on Wolverine and lesser-prairie chicken. I also put streak-horned lark up here because for folks who are in the Pacific Northwest, we also have a really bad 4D rule for streak-horned larks. And just talk a little bit about what Fish and Wildlife Service is doing now. So, the Wolverine, nature's original mountain climber, pretty impressive species. It was proposed for listing as a threatened species last February. It has a 4D rule that proposes to allow incidental take from a whole host of activities. So, snowmobiling and skiing, logging, fire management, development, road building, all sorts of things. So the 4D rule on its face is incredibly broad. This is even broader than anything else we've seen from Fish and Wildlife Service. Pretty large group of activities, pretty much anything that's happening within the area of the Wolverine is getting exempted by this, but that's really actually not the kicker with the Wolverine rule. What Fish and Wildlife Service did is, in addition to saying all of those activities are exempted from incidental take, they also define what is prohibited. And as you can see from this language, and I don't want to read it all to you, it is incredibly limited, the things that actually are prohibited for the Wolverine under this draft 4D rule. And so to me, I think this is one of the scarier 4D rules that we've seen, because it's not just saying these things, you're allowed to do these incidental take things because of the conservation purposes of that. The Fish and Wildlife Service took a step further and actually said, we're also going to limit where Section 9 is applying, and it's going to be an incredibly short list of things. So that's the Wolverine. The lesser-prairie chicken is also, though, to my mind, a pretty horrific, pretty scary 4D rule. But it's very, very different from what the services did with 4D. And I think that despite the fact that it's named as the lesser-prairie chicken, it's actually a grouse species. And for you guys who don't know anything about them, they're amazing dancers. They're really beautiful, awesome birds to watch. But I also think that if you care about grouse in its many different forms, this is a rule to look out for, because we're seeing what Fish and Wildlife Service is doing with lesser-prairie chicken, with what they're now calling the bi-state sage grouse, and I think that they're trying to set a stage for other grouse listings. So lesser-prairie chicken is going to be a really, really important battle. And what that 4D rule does is it's very different from what they did with Wolverine, as I said before. Section 9 applies, and then they created this exemption for incidental take from certain programs designed for the species conservation. And that sounds pretty good on its face, right? Oh, you have these conservation programs, yeah, they should get a get out of jail free card. But there are two ways where what Fish and Wildlife Service did was really flawed. And the first one is they used what they called a net conservation benefit standard. And you're like, what's that? Where does that come from? It doesn't come from the Section 4 land. It doesn't come from the definition of conservation. It's actually a concept that Fish and Wildlife Service uses in the Section 10 permitting process. That's a standard that you have to meet for safe harbor agreements. And so they took that standard from Section 10 and are using it to be able to try to justify this 4D rule for the lesser-prairie chicken. The other thing that they did is they relied upon these draft voluntary programs. And so for those of you who actually litigate on endangered species issues, a lot of times you'll see the services use these sort of draft voluntary programs as an excuse for not listing the species at all, right? So there's some good case law on that. That case law is also incredibly helpful in looking at these 4D rules, because it's the same rationale. How do you know that these programs are going to conserve a species if A, they're not final, we don't have any indication of how they're going to be implemented on the ground, and B, they're voluntary. We have no idea if anyone's actually going to even engage in these programs. And so I give you guys a couple of cases that are useful that have sort of made those arguments. And it actually came up in the context of a 4D rule in the no fisheries context, where the court said, no, you can't use these voluntary draft measures as the basis for a 4D rule. And the programs that they're looking at for the lesser-prairie chicken are twofold. One of them is a program by the state wildlife agencies, where they've come together and said, okay, this is what we're doing for lesser-prairie chicken in all of these states. They finally finalized the plan. We still haven't seen its implementation on the ground and whether it's actually going to conserve the species. And then the other plan is, it's funded through the Farm Bill, and it's a Natural Resource Conservation Service program. So it's one of these ag subsidy programs. So they pay farmers to keep habitat in a certain condition, and that's beneficial for lesser-prairie chickens. And so to me, really, why the lesser-prairie chicken is a great example of why they shouldn't be doing this with Section 4D is because you have these two different parts of the 4D rule that fit perfectly under the existing statutory regime of the Endangered Species Act. So typically, when you have state agencies that band together and create a conservation plan, they get a Section 10 permit. So for people who are familiar with that, under Section 10 you can get permits to incidentally take listed species as long as you have a plan to conserve that species. Fits perfectly with what's going on with lesser-prairie chicken, what the state wildlife agencies are up to. I have no idea, well, I have some theories on why they're not going through the Section 10 process. You have to consult, you have to do a NEPA process, you have to actually disclose a lot of information. We're not getting in the 4D rule context. There's also monitoring that happens and information that's available to the public. And so by choosing to go the 4D route, in essence, what Fish and Wildlife Service is doing is creating these rules that are a black hole. There's no information that the public will ever get, there's no timeline on them, they remain in effect forever, and we don't get any information. And then with the NCRS program, again, it's a federal agency that funds and operates that program. They can consult under Section 7 of the Endangered Species Act. It's a federal agency, they're funding this program, and take authorization under Section 7. But again, under Section 7, they have to pass the no jeopardy standard. And so it makes you wonder, why are they doing this in a 4D rule? Are they worried about Section 7, and is that why they're doing this as a 4D rule instead of just consulting? So I will leave you with those questions and my answers to some of those questions and pass it on to
Thanks, Tanya. As Tanya mentioned, rules issued under Section 4D of the ESA are supposed to support the conservation of the species, which, under the plain language of the statute, can include regulating taking, but only in extraordinary cases where population pressures within a given ecosystem can't otherwise be relieved. And so what I'm going to be focusing on is the Fish and Wildlife Service's attempts to allow sport hunting and trapping under the theory that it supports the conservation of the species. And this plays out differently whether you're talking about the domestic hunting or internationally hunted, and where the take occurs, and whether it's shooting an animal in the United States or trying to import the trophy back into the United States. And I'm going to also look at the straight-horned markhor proposed rule in particular. It's a species that exists in Pakistan and Afghanistan and is currently listed as endangered, though the Fish and Wildlife Service has a proposed rule to downlist and issue a 4D rule. So domestically, there have not been a lot of instances in which the Fish and Wildlife Service has authorized the sport hunting of domestically listed species, and I think that that's due to the fact that a number of their early attempts were rejected. So one of the first cases was Sierra v. Clark out of the 8th Circuit from 1985. And in that situation, the Fish and Wildlife Service had authorized Minnesota to allow sport trapping of wolves in 3 different areas in the state, and only established a quota in one of them, although required a certain number of wolves per square mile in the other 2 zones. And the plaintiffs challenged that rule, claiming that it violated the plain language of the statute. And the service argued that, pointing to the discretionary language in 4D and some legislative history that referred to the service's infinite number of options when it comes to the management of threatened species in support of their decision, the court rejected that argument. It said that the plain language of the statute requires that before the taking of a threatened animal can occur, the determination must first be made that population pressures within the animal's ecosystem can't otherwise be relieved, because otherwise the taking wouldn't constitute an act of conservation and would fall outside the scope of the authority granted to the Fish and Wildlife Service. However, because Fish and Wildlife Service relied just on their discretion under 4D of the ESA, they had made no determination that there were population pressures or that the extraordinary circumstances existed to allow Section 4D to be invoked here. So that decision, or that Fish and Wildlife Service's rule was vacated. The next case that dealt with this is in the grizzly bear context of Fund for Animals v. Turner, and in that situation, the Fish and Wildlife Service allowed the sport hunting of grizzlies in northwestern Montana. They did establish a quota this time. It was 14 bears, only 6 of which could be female per year. And this time, in contrast to the Sierra Club case, they did make a determination that the rule was necessary to relieve population pressures, which was indicated by the movement of bears outside of their current range into more populated areas, and then also that the increased human and bear interactions were creating a risk to both the species and people, and that allowing a limited sport hunting would make bears wary of humans, so they would then just stay inside their normal range, and it would be a benefit to the species. And the court rejected the service's first justification as contrary to evidence in the record that said that they don't really know why these bears are leaving. It was not necessarily due to population pressures within their ecosystem. And their second justification is contrary to the plain language of the ESA, which indicates that Congress is referring to population pressures in a limited ecological sense, where the animal exceeds the carrying capacity of its particular ecosystem rather than in a looser sense of pressures between bears and humans. And the court also noted that 4D did not authorize hunting whenever it would be a sound conservation tool, but specifically limited it to extraordinary cases that didn't exist in this context. Now, on the international side of things, as I said earlier, it generally applies when a hunter has gone to another country and is trying to import that trophy. And when I say trophy, I mean the taxidermied animal or their head that you're hanging on your wall here. And I think the straight-horn marker proposed rule provides a good example of this situation. I mean, not good if you're a straight-horn marker, but so they're currently listed as endangered under the ESA and on Appendix 1 under CITES. And pursuant to the ESA, their import is only allowed pursuant to a scientific research permit or an enhancement permit under Section 10 of the ESA, which has to go through notice and comment and is a higher bar to reach to prove that the import will enhance the survival of the species. And as an Appendix 1 species, under CITES, you also need an import and export permit, and it requires a non-detriment finding. And an import can be detrimental if it's an unsustainable use, or it would lead to habitat degradation, or interfere with recovery efforts, or lead to a further stimulation in trade. And then separately, there also needs to be a determination that the import is not for a commercial purpose. So there's a number of things that currently exist that an importer needs to prove in order to import their trophy. But under the proposed rule, the regulatory landscape would change. I mean, they are still listed as Appendix 1 under CITES, so it would still require an import and export permit. However, they're being proposed to be downlisted to threatened. That's despite the fact that the rule talks all about how the populations, except for this one area in northern Pakistan, is actually declining, that they're still threatened by hunting, and that poaching is still a problem, but nevertheless, they're proposing to downlist them. And they're also issuing a 4D rule along with that downlisting that would allow the import of a trophy with no ESA permit requirement. So there'd be the only findings that would be required are these 5 specific things, which may look like a lot, but basically all it says is that there needs to be some sort of conservation program in effect, and that you're giving money to this local community, and that money is benefiting both the community and the species. But it's really, really vague, and I'm going to talk a little bit more about some of the more specific problems in a minute. But the service's justification for this 4D rule is what we call pay to play. And it's the idea that if you give a bunch of money, then you can go to other countries and kill a listed species and bring that trophy back for your trophy room. And they're under the theory that if you give money to a local community to be able to go hunt a species, then that community has an incentive to maintain whatever that population is. I mean, I think that there's a number of problems with that justification, because then you are, commodifying a listed species, and it's this ironic situation in which the rarer and rarer the species gets, as it gets more and more hunted, the more valuable their trophy becomes, so that you're actually could be encouraging poaching and things like that. And then there are also a number of specific problems with that justification in this particular context, because throughout the proposed rule, Fish and Wildlife Service talks all about how Afghanistan and Pakistan, while they have certain environmental laws that are in place, enforcement of those laws is really, really lax. So how do we know that the money that they're supposed to be paying to some local community is actually going to benefit the species, especially in countries where they don't really do much enforcement? And as I said earlier, the rule also talks about how the hunting is still a threat to the species, and in fact was one of the reasons, the primary reason that the species was listed under the ESA in the late 70s. Another justification of the Fish and Wildlife Service is that Pakistan recently increased its export quota for the straight-horned markhor from 6 to 12 per year. But as you can see from the limited findings that are required in order to authorize the import, it's not limited to species from Pakistan. There's other straight-horned markhors in Afghanistan, and it's vague enough that they could allow even more than 12 animals to be imported. So it's a terrible, terrible proposed rule, and they're also cutting the public out of the process here too by not requiring any sort of permit, and so we lose our opportunity for notice and comment on these proposed imports. And some other issues with this rule and similar 4D rules that allow the import of listed species. The National Environmental Policy Act, in the proposed rule, the Fish and Wildlife Service says that they don't have to do any NEPA based on their 1983 policy for listing decisions under Section 4A of the ESA. But as we pointed out in our comments, that does not cover decisions made under 4D. And Brendan's going to talk a little bit more about that in the polar bear context. Another interesting question is Section 7 consultation and whether that applies here. The service does not do it in these types of situations. And presumably under their theory, there'd be no adverse effect on listed species because they're doing it for their benefit. But there's also other listed species that exist within the range of some of these species that they're trying to import, and in the straight-horned markhor context, that was a little too early there, but in the straight-horned markhor context, there's another listed species, the snow leopard. They share the same range, but they also prey on straight-horned markhor. So if you are through this rule, they could, really value, at least from the economic perspective, straight-horned markhors over snow leopards, which local communities could then not really focus on conservation efforts for snow leopards, or even try and eliminate them so that there will be more straight-horned markhors. Another issue is that challenging these types of 4D rules and the import permits that are issued in particular is really hard because of standing. And there's this case out of the DC District Court in 2003 in which the plaintiffs challenged an import permit for Argarli sheep from Mongolia and Kyrgyzstan. Sorry, I don't know how to pronounce that. And they got thrown out on standing grounds because the court said your injury stems from the sport hunting that's occurring in these countries, and government is going to allow those hunts regardless of what the Fish and Wildlife Service does here, so you have no redress. They found that despite the fact that the plaintiffs had submitted some evidence that hunting would increase if Fish and Wildlife Service did allow these import permits, but the court said no, that was too speculative. So it does leave the door open to be able to potentially jump over that standing hurdle if you did have evidence that the particular imports would lead to further hunting. But based on the language in the court opinion, that seems to be really, really strong. The plaintiffs also alleged an informational injury, but the court rejected that as well because they said no, your statutory right to notice and comment only applies to endangered species, not to threatened species. And then even if you are able to get over the standing hurdle and get to the merits, there's at least some language in the statute that supports Fish and Wildlife Service's position in some of these situations. Section 9C of the ESA presumes that the import of a threatened species that's listed on Appendix 2 of CITES will not violate the ESA. So that just creates another hurdle in challenging these permits, because at least for Appendix 2 species, because it sort of supports their notion that maybe the pay-to-play concept it has some street cred, but I disagree with that on a number of levels, most of which I've already communicated. In closing, I thought I'd leave you with the words of Stephen Colbert. This is from a skit that he did following the Dallas Safari Club's announcement that they were going to auction off a permit to hunt black rhinos in Namibia. And I was hoping to play the clip, but it's maybe a little too raunchy for a Sunday at 9 a.m. But if you just Google Stephen Colbert, black rhino, you should watch it. And just in case you can't see that, and I can't deliver it the way he does, but they say if you love something, set it free. Then when it has a bit of a head start, open fire. And people say, why don't you do a photo safari? Well, you can't do a photo safari. People don't pay for that. A photo's not a trophy. You can't hang a photo on your wall. And with that, I'll turn it over to Brendan.
Good morning. Thanks for all showing up at this hour. It's already a little late, so we don't have the excuse of my incoherence of the earliness. But anyway, I'm going to talk about climate change and 4D rules. And if we had this talk 5 or 6 years ago, this would have been an extremely interesting, pressing issue, because during the height of polar bear fever in 2007, the proposed rule, in 2008, the final rule, the whole public context and dialogue over the listing of the polar bear was, is the Endangered Species Act going to be used to regulate greenhouse gas emissions? We did not yet have regulations under the Clean Air Act. There was not much going on under the Bush administration. And so there was this big sense that in addition to the informational precedents and the scientific precedents that listing the polar bear would bring, that it actually might lead to real regulation of greenhouse gases. 6, 7 years later, not quite the case, and so I'll get how we got there. But people often think that the polar bear is the only species that was listed and has a 4D rule vis-a-vis climate change. And it obviously was the high-profile species that got the world's attention. But it actually wasn't the first, and it wasn't the last. So I'm going to talk about 4 rules, 5 species, or actually 5 rules. The ringed and bearded seals were separate rules, but identical. And how the agencies altered their treatment of this over the years. And one of the things I want to make clear, as Tanya mentioned, Fish and Wildlife and National Marine Fisheries Service have split jurisdiction over the ESA, and NMFS has jurisdiction over most marine species, like corals, like seals. Fish and Wildlife has the polar bear and wolverine. And one of the key differences between the two agencies is Fish and Wildlife, years ago, did the blanket 4D rule. So the default, when you have a threatened listing under Fish and Wildlife, if there's no 4D rule, the species gets full protections of Section 9. For NMFS, the agency doesn't have a default 4D rule. So for a species to get any protections from Section 9, NMFS has to affirmatively do a 4D rule. So it creates this strange thing that 4D rules from Fish and Wildlife are almost always a bad thing. 4D rules from NMFS are a good thing. You want them to do a 4D rule. The other context issue here is, as Tanya said, 4D only applies to threatened species. Although there is one exception where NMFS managed to apply it to an endangered species, but that's a complicated story I won't get into. But because you can only do it for threatened species, often that's what's driving the determination between whether the species should be listed as endangered or threatened. So when we talk about fighting 4D rules or ensuring the number 4D rules, often the more important battle is the question of, is the species endangered versus threatened? And because the question of endangered versus threatened is a best available science standard, you might actually have better chances of winning that battle than necessary advisable standard, which loses discretion. So, elkhorn coral, staghorn coral, these two Caribbean species that declined by 80+% into the 90s%, a host of threats to them, but the primary one is bleaching. As ocean temperature warms, they expel their symbiotic algae and essentially starve to death. This was the first ESA listing that where the agency recognized climate change as one of the major threats to the species. It wasn't the only threat compelling listing the way it was with the polar bear, but it was recognized as one of the major threats. And this is Bush administration, actually when they listed the species, they subsequently did a 4D rule. And it actually, if you look at it, it's basically Section 9 applies. It's actually quite a good 4D rule. Everything goes down here, hill from here. But they did. The only real difference from the full Section 9 prohibitions is they loosen up the standards for scientific research permits and restoration permits, which is also possibly a good thing. In ESA listing decisions, the agencies have a policy of describing the type of activities that might result in a take, in a Section 9 violation. And those descriptions don't have any true regulatory force, but they're certainly helpful if you're bringing a take claim. And if you're in any kind of battle with an agency over what may affect the species. And here, NMFS again, in a pretty clever rulemaking, they got it through the Bush administration. Nowhere in it does it use the phrase climate change, global warming. The scientists managed to write it in a way that captures all of those things, but cleared the OMB filter for the word climate change. No rule shall pass. And the first one, they describe about activities modifying water chemistry. And that's, your high alpha logs and things of that sort, but arguably that sounds a lot like ocean acidification to me. The other one, which is less good, is they describe elevated water temperatures, but their only example is local activities. They don't say anything about can't be national, international activities, but that's the counter argument. So polar bear is next in the queue, and we did this petition in early 2005, and ultimately got the listing in May 2008. And the 4D rule went through a few iterations. So when they did the listing, they did an interim 4D rule. They had never proposed a 4D rule along with the listing like they did, say, for Wolverine and various other things that's been talked about. Because it was the agency was all over the place in terms of what they were actually going to do, they drafted at the last minute this interim rule, went into effect immediately, that essentially exempted greenhouse gas emissions. I'll get to how they did that. They then finalized that rule, again, late in the Bush administration. Congress actually passed a good rider giving the Obama administration the opportunity to rescind this rule without any notice or comment or anything. Basically, Congress was like, hey, the Bush administration is doing these horrible rules that are against the effort to regulate greenhouse emissions. They're upsetting the Endangered Species Act and the polar bear. And it was like, will Obama do it? And unfortunately, Secretary Salazar adopted the Bush rule and stated the ESA should not be used for climate change. And that kind of shifted the policy debate. Prior to that moment, because of the political climate under the Bush administration, you had this interesting partisan dynamic where Republicans were saying we're climate deniers. The Democrats, the more progressive ones, were seeing the ESA as a possible angle for activity. And so you actually had Congress pass a bill saying you can rescind this restriction on the ESA. As soon as Obama embraced it, there became a bipartisan consensus that the ESA is the wrong tool. And that just switches the dynamic you have in front of the media, in front of judges, in front of everything. And that's really the point where we've lost this battle, even though there's been multiple legal steps along the way. So we filed suit, and we actually won. It was a rather Pyrrhic victory. We won on NEPA grounds, and the judge vacated the rule. And subsequently, Fish and Wildlife came back and issued the exact same rule, but with a different justification. So, what does the rule do? That's small text. You probably can't see much, but the two things is, the first part is it exempts activities in polar bear range that are otherwise authorized under the Marine Mammal Protection Act. Polar bears are considered a marine mammal, and as well as under CITES. And this was basically for the benefit of the oil industry operating on the North Slope. It was, let's not bring the ESA into the mix. You're already regulated in some manners under the MMPA. The more important climate one is they said none of the prohibitions that apply if the activity impacting the bear occurs outside of the range of the polar bear. So they don't say greenhouse gases, but what it means is a smokestack in the lower 48 emitting greenhouse gases is outside the current range of the polar bear. And so that was their method of doing it. And they, in their subsequent rule, to rush it through the interim status, they did all sorts of contradictory things of how that rule would benefit the polar bear because MMPA was more flexible for on-the-ground impacts and things of that sort. But later on, as each step of the process, they got a little more honest about it. They basically say there's no conservation benefit. That the only threat to the polar bear is loss of sea ice. There's nothing in our authority under Section 9 that would actually address that. Therefore, there's no conservation benefit. This is a really dense one that's hard to read. But remember, when we're talking about Section 9, it's the take prohibition. The take prohibition only matters if it's actually implemented in some way. And one of the duties of the Endangered Species Act is there's a citizen suit provision. So usually with Section 9, our hope is that the service would prosecute a violation of Section 9. That rarely happens. The take prohibition often compels regulatory action, but Section 9 cases are almost always brought via citizen suit by NGOs. And in the final iteration, this is the Obama rule, they basically say the inability of a citizen group or private citizen to bring a separate action under the ESA does not have a conservation effect on the species. So they basically make a policy pronouncement writing out the benefits of citizen suits. And then their necessary and advisable finding is the director of the service has therefore made a reasonable policy decision that where there is not a conservation issue for the species, the potential burden of baseless incidental taking lawsuits to industry and others most likely subject to such lawsuits, blah, blah. The benefit of allowing citizen suits for ESA to take violations outside polar bears is outweighed by these considerations. So basically, we're going to shield industry from lawsuits. That's the advisable for the conservation of the polar bear. And they toss in there a little bit, if you brought such a lawsuit, the service would somehow have to get involved, and that would distract us from doing these other important actions to protect the polar bear, whatever those actions might be. It's a case worth reading. There are a whole bunch of polar bear cases of different types challenging the listing for being underprotected, overprotected, dealing with import provisions, sport-hunted trophies, and whatnot. All got consolidated. There was about something like 1,700 pages of briefing. We had to write 26 substantive briefs. So there's not like an easy thing to like, here's, read this to figure out what happened. But the gist of it is we lost on the ESA claim that the rule did not support the conservation of the species. We won on the NEPA claim. And what that meant is the judge vacated the 4D rule, which had the same interesting effect of that made our loss on the ESA claim unappealable because that rule didn't exist anymore. But because there was this interim rule, so usually when you vacate a rule, you go back to the rule's gone, and if there's another rule in place that existed before it, that may go in effect. With any other species, if you vacate the 4D rule, the default becomes the blanket prohibitions at 1731. For the polar bear, the judge did this nice little convenient thing of you vacate the rule. There's also this interim rule that was done with no notice and comment or any of those things, and that was reinstated as the provision. So we won, but we didn't really get anything. And then we went through this process, including NEPA or that in the Obama administration, the identical rule. There's multiple things in the case, but the gist of it is, with Fish and Wildlife, because of their early regulation, the baseline, absent the species-specific 4D rule, is full protection under Section 9. The 4D rule almost always reduces that protection in practice. And what the court said, plaintiffs are correct. In the absence of a special rule, management of the polar bear under the ESA would be governed by the general rule set out in 50 CFR 1731, which extends all of the Section 9 take prohibitions to all threatened species. But here's the part we don't like. Nothing in the regulation or the ESA itself requires the agency to demonstrate a conservation basis for not applying the general regulations at 50 CFR 1731. So, as long as the specific measures that are in the 4D rule provide a conservation benefit to the species, that's enough. You don't have to justify deviating from the rule you already set. Because remember, the statute says only endangered species get a take prohibition. For threatened species, you get a take prohibition if there's a 4D rule. The service issues a blanket 4D rule for everything saying you've got take prohibition. But that rule says, and we will modify it as appropriate species by species. And so our argument was, in essence, the regulatory baseline is blanket protection because of that regulation. And you have to show a conservation benefit to deviating from that rule. And the court said no, because that blanket protection is not part of the statute, and that regulation also contemplates species-specific rules. Where you measure conservation is the specific terms, and they said, yes, applying the MMPA take prohibitions conserves the polar bear. With the Wolverine, it would be applying the prohibition on intentional take would help conserve the Wolverine. And you don't have to address all the threats, or even the most important threat, as long as there's some benefit. I'll move on quickly and then come back to the other species and come back to possible paths forward. Bearded seal, ringed seal. Both of these were ultimately listed. In 2010, NIMS issued the proposed rule, and in a barely noticed portion of the rule, there was the proposed 4D rule, which was great. prohibitions of Section 9 apply. It's like, oh, if they actually go through with this, you know, it's harder to prove take of the bearded seal than it is of a polar bear, but, which is a whole separate question, can we ever prove the Section 9 greenhouse gas violation? But it was looking good, and they did the same thing for the ring seal. But in the final rule, a certain individual in the administration inserted themselves into the process, and they basically said, principal threat to the species is climate change. It's a long-term threat, and consequences won't really manifest themselves for the next few decades. So any take that happens in the interim, no big deal. And we therefore conclude that it's unlikely that the proposed Section 4D regulations will provide appreciable conservation benefits. As a result, we concluded they're not necessary at this time. So, final rule, there is no 4D rule for the ice seals, which means there's no take prohibition under the ESA. You know, fortunately, they're marine mammals, so you have the MNPA providing some protection. Wolverine. So, this one, it's a strange rule because it says what's prohibited and it sets what's allowed, and there's a big sort of silent space in the middle, you know. But what's prohibited is any activities, the direct take, the shooting, the trapping. There's the second sentence, which I wouldn't be surprised is missing from the final rule. It will also be prohibited to incidentally trap, hunt, shoot, collect. So direct take or incidentally catching them through trapping or hunting activities. We'll be lucky if that sentence is still in the final rule. We'll be fine over that. What activities are allowed? Anything. Any otherwise legal activities involving wolverines in their habitat. So, you know, as Tanya said, you can build a ski resort, you can bulldoze their habitat, you can, you know, bulldoze them in their dens, and that's not take. And it doesn't say anything about climate, but smokestack emission is presumably an otherwise legal activity, and it's certainly not, smokestack emission is not trapping, hunting, shot, captured, or collected. So it exempts greenhouse emissions, even though the agency said the primary threat to the wolverine in the lower 48 is climate change. They also, not in the rule itself, but in the regulatory preamble, had a brief discussion because they're obviously the issue is there, but they straight up say, if we list it, it will not regulate greenhouse gas emissions. That's our policy position. Whether it's Section 9 or Section 7, listing doesn't regulate emissions. So, where do we go? Other than challenging these rules, and the polar bear saga, which was consolidated in DC, is not necessarily over, but there's sort of a pause in it. And given the difficulties of things, and unfortunately the horrendous plight of the polar bear, uplisting to endangered may be actually the path forward for the polar bear rather than the next challenge, the 4D rule. But one of the issues that came out in the briefing, and it didn't seem to occur to the service at all in the issuing of the rules, but the intervener lawyers brought this up, is, as Tanya mentioned, if you read 4D, there's those two sentences. Whenever the species is listed, you shall issue such regulations necessary and advisable to provide for the conservation. Second sentence, you may impose any of the Section 9 prohibitions. So, Sweet Home, the DC Circuit case, which has the easiest to remember citation, 1F third 1, dealt with this issue, and it dealt with it at the time the ruling was a good one, which was Fish and Wildlife had their blanket 4D rule. Industry challenged and said, hey, you didn't make species-specific conservation findings as to this 4D rule, and you didn't even make much of a finding conservation-wise for it at all, and that's not justified. And what the court did in upholding it said, actually, there's two sentences, two separate grants of authority under 4D. One is you may apply Section 9, and you can do that without even having to find a conservation benefit. So Section 9 or any subset thereof you can do without a conservation benefit, and on that grounds we uphold the rule. But what they say is the second sentence contains the necessary and advisable language that mandates formal individualized findings. This is the DC Circuit saying it. This sentence requires the Fish and Wildlife Service to issue whatever other regulations are necessary and advisable, including regulations that impose protective measures beyond those contained in Section 9. So the fight forward might not actually be what they're doing in their 4D rule to reduce Section 9 and provide only a subset of Section 9, but their lack of doing this other sentence of an affirmative, specialized rule that actually addresses the conservation needs of the species. And so the argument in the polar bear case that industry raised is because the prohibitions they raised, they applied were a subset of Section 9. There's not a conservation standard, therefore our claim saying there's no conservation benefit goes away. What we were able to do was point out that in the rulemaking itself, Fish and Wildlife repeatedly said these are necessary and advisable for the conservation. So Fish and Wildlife was treating it as blurring the two sentences together. And so the judge said, I'll rule on this on the standard, the standard they articulated that they were applying, which is the conservation standard, and say the rule still survives under the conservation standard. So as you go forward in 4D rules, be very close look at which sentence are they using and basing it upon, or are they basing it upon both sentences? And the way forward may be forcing them, which is a whole other difficult subset, to apply species-specific 4D rules that go beyond Section. So where does this leave us with the polar bear and greenhouse gas Section 9 litigation? If you've gone to any of the standing panels or read any recent case law, trying to bring an ESA Section 9 case, even if, say, polar bear were listed as endangered, would obviously be very difficult. And in the Ninth Circuit, under the recent opinion, it's arguably, it would be almost impossible to get standing. Not impossible, but almost. And then you'd actually have to prove the take, and is a contribution that's only part of the cause. You know, any individual action is only one contributor to atmospheric CO2 levels. The harm that's occurring to polar bears right now is based on the warming that's happening from past emissions. It gets very complicated. We think we could do it if we had the bear as endangered, but there's hurdles. We can't do it until and unless we either uplist the bear or get rid of the 4D. Or you could do it with a different species, but the bear really is the one where everything crystallized, where the facts are the best. But I put this up as a chart that shows why should we bother with ESA listing species threatened by climate change if we can't actually address the primary threat to them, which is greenhouse gas emissions. And this is the modeling done in the lead up to the listing of the polar bear by USGS, and then was subsequently published in Nature. And the general thing to note is these are different CO2 scenarios. If you look at this third column, the virgin ice ecosystem, which is bears in Alaska, think of red as extinction probability. So we'll look at this one. This is the best case if we keep CO2 levels below 450 parts per million, which is very difficult, but some possibility of doing it. If we do that, polar bears have a 50% chance of survival. So that's even if we actually reduce it. If we don't reduce our emissions, they have a 15% chance of survival. But you add best management, which is reduce other threats to species, the direct killing them from the trophy hunting, oil and gas development in their range, a whole range of things that can affect the species. The extinction risk drops by about half. And so all these species threatened by climate change have an incredibly rocky future ahead of them. And it's, if you pay attention to climate politics, things are pretty bleak. But if we do everything else to protect the species, including enforcing to the degree possible all the other standard conservation measures contained in the ESA, we can greatly reduce their extinction risk. And that will hopefully buy us time with the whole other toolbox of activities to address climate change, including Clean Air Act and social movements and everything else that will significantly increase the chance of polar bears and other species surviving. So that's why we're keeping on. And 450 is not good enough. 350 is where we need to go. And with that, I'll stop.
Any questions? Yes.
Yeah, I've got a couple questions for you guys. Do you think there would be any value in including suggested 4D language when we submit listing petitions? And then my next question is, as you know, there was a rider recently that undid the win for those 3 antelope and that permit exemption, but it didn't have any judicial review language in it. Do we know where Fish and Wildlife Service is on that, if they're planning to get that changed?
I definitely think including proposed word rule language in listing petitions and in comments on listing proposals is definitely the way to go for sure. I cannot speak on the antelopes, what the services are thinking. I don't know if you or anyone else knows.
What I would say on the proposed 4D language, often, certainly in your petition, depending on what you're asking for, if you can make a credible case that it's endangered, then it's endangered, and 4D is only a backstop. And the proposal off the front should be all section 9 plus XYZ that's additional to the specific needs of the species. Once it reaches the stage of proposed rule, and either it's a nymph species and there's no 4D rule, or Fish and Wildlife and it's traveling, then absolutely alternative language is good. And if we're ever going to implement that other grant of authority mentioned by Sweet Home, the question is how we do it. Can you sue the agency at the final rule stage for a listing for not doing it? Or is it a separate command where 4D is done as a separate rulemaking? There's no timeline on it. When do they have to do it? Is that an ESA citizen suit? Or do you have to petition for the specific 4D rule and then sue over that under the APA combined with it being an ESA non-discretionary? So there's a world out there where this is going to go and should go, and it's totally untested waters. With the corals, the first one, we had NIMS didn't issue a 4D rule at the time of listing, and it was it took them a while. 2006 was the listing. 2010 was when we finally got the 4D rule. In the interim, at a certain point, we drafted up a petition, for a 4D rule that addresses climate change and whatnot. And we never actually submitted that because at a certain point we heard that the agency was actually going to issue quite a good 4D rule. And so we held off and let them do the 4D rule without drawing any attention to it. And then the other example of that those corals, is now 8 years later, even though we have a good 4D rule, through the changes in science, and unfortunate, through how bad ocean acidification and climate change are, NIMS has actually proposed to uplist those corals to endangered. So we should see them and multiple other corals listed as endangered species, which then opens the door for the possible Section 9 ocean acidification case or something of that sort.
Given how broad take is defined, what's something you envision with that second grant of authority in this week? What would be on section 9?
Well, the examples of good 4D rules are nymphs, sea turtle, the TED requirements, that not only do they say you're not allowed to kill turtles in a shrimp net, they say all fishing vessels catching shrimp in these zones must include these things to avoid catch or reduce catch of turtles. So they could issue a 4D rule for Wolverine banning laser traps in the range of the Wolverine. That grant of authority lets them do that. There's all sorts of things that they could do that come short of actually having to affirmatively prove take, so long as they can show that it has a conservation benefit. So if we had a good service, we might get that. And fortunately, in the past few weeks, the new head of NIMS is really quite a good appointee. So we might see some good stuff coming out of this. Fish and Wildlife.
Yeah, Kristen, you briefly mentioned this, but I was wondering if any of you guys had thoughts on the kind of the interaction of the 4D rules and the consultation requirements, and whether the exceptions have any impact on consultation requirements.
Yeah, there's actually a case in the Western District of Washington. It was a 4D rule challenge that said that they did have to consult under Section 7 before issuing a 4D rule and undertake a jeopardy analysis. Obviously, you're not going to have finalized, most of the time you don't have finalized people haven't done at that point, but yeah, you have to do the jeopardy analysis and look at those exceptions or the quote-unquote conservation purposes for that 4D rule and what its impact is going to be on the species.
So I meant more for,
Subsequent.
yes,
Yeah.
after the 4D rules.
So yeah, so there's two issues there, because do they have to consult, like courts have pretty much clearly said now they have to do NEPA when they do an ESA rule, a 4D rule. Do they have to do an ESA consultation on it? And the example I was going to say of doing a 4D rule for an endangered species, and this was sort of a good one, but the way they were able to use a 4D rule to exempt take for endangered species is for sea turtles, for the TED rule, the turtle excluder device. They consulted on it, and that consultation resulted in a biological opinion with an install take statement that also authorized take for the endangered sea turtles. So the 4D rule for the threatened turtles gives you the TEDs. The consultation and its terms and conditions gives you the same requirement for an endangered species. So that's one scenario that goes for. The other is, if you have a 4D rule, do you need to consult? Does that alter the consultation? And yes and no. So if the Ninth Circuit has addressed this to some degree in a polar bear case, it's CBD Salazar, and there it was consultation on MMPA regs, and there was this whole question of because the polar bear 4D rule only applies MMPA prohibitions, is take actually prohibited by Section 9 of the ESA, and if you don't have a take prohibition, you still need an incidental take statement. Incidental take statements are the part of consultation that often gives you the good stuff, the terms and conditions, the monitor, the things that you can enforce and sue them later for violating the law. And so the law is nebulous, but in the Ninth it's good. If there's a 4D rule that exempts take, does there need to be an incidental take statement in any biological opinion? There's still agency actions that affect the species, but you might not get an ITS. So that's I think where it's most going to fall out.
And I think you're definitely not going to get an ITS in the import permit context, because there the agency doesn't see themselves as authorizing take, they're just authorizing the import of the species. And in the straight-horn markhor proposed rule, they did not even find that there was population pressures. They just sort of ignored that part of the statute and the prior case law on that. And in fact, the population is declining, as I mentioned. So I think that they see the import side very differently.
And that gets complicated as well as the take, the thing that fits within the definition of take, the shooting of the animal, occurs in a different country. Section 9 explicitly doesn't apply in that country, but does an act that takes place in the U.S. that's the legal cause of the take, result in a take. And where does the action occur for Section 7 purposes when you're issuing an import or export permit? But that's a whole other fun area of international applicability of the ESA.
Yeah.
Are we doing NEPA on a 4D rule? Have they done NEPA on the chicken or the Wolverine? Because they're relatively short. So they don't seem to have gotten that out of.
No, although it'll be interesting to see if they end up issuing any EAs, because I've seen some stuff in the FOIA records. They actually went through and counted up, and I think of the sort of 42 4D rules Fish and Wildlife Service had in the table, they've done NEPA on it's like 12 or 14 of them. So they know that there's some precedent within the agency for doing that, and it's been raised in the comment period, I think, for both those species. And so it'll be interesting to see if we end up with an EA with no public comment.
Just throw it out at the end.
That's my guess.
Right, because there's one district court case, well, there's the Polar Bear DC district court case saying you definitely have to do NEPA. There's a Northern District of California case saying they don't need to do NEPA on new rules. And then there's some blurry ones with NIMS. NIMS does NEPA as a matter of course, and the court just assumed they were going to do NEPA it's not clearly said.
But I think it is something, if you're thinking about venue and looking at these rules, to keep in mind, you know, yeah, you have a district court case in DC that says, yes, NEPA, the district.
But no
court.
conservation.
Yeah, right, so it's sort of, yeah.
So yeah, so you may want to bring in the Ninth Circuit, try to get the conservation